Hello, welcome everyone. Thank you for joining us today. Um, my name is Ricky Bentley. I am the program manager at Connecticut Land Conservation Council, or CLCC. We are the statewide umbrella organization for the Connecticut Land Trusts. We work to advance efforts through advocacy, funding opportunities, and technical assistance and capacity building programs like this webinar series. This session marks the launch of our 7-part Anatomy of a Land Transaction webinar series, designed to give land trust staff and board members a strong practical foundation in the key components of land conservation deals. If you haven't already, I encourage you to subscribe to our e-news. It's an easy way to stay connected with upcoming programs and resources. Today's program is Environmental Due Diligence. Know what you're getting. Uh, Before we begin, I just want to do a few quick housekeeping notes. Please feel free to add your questions to the chat. We'll address them at the end. We'll have time for a question and answer session, but we want to leave time for the presenters. To help preserve bandwidth, we ask that you remain muted and keep your video off until the discussion at the end. And finally, the session is being recorded. We'll make the recording available on our YouTube channel and can share it out afterwards. The next session will be the same time next Friday. Now, I'm delighted to introduce our presenters. Cameron Beard is a board member and chair of the Stewardship Committee for East Haddam Land Trust. He's a retired attorney with decades of experience in international and maritime law, and is a certified master woodland manager. Remains active in forest stewardship and land conservation efforts in Connecticut. And Tim Myjak, a licensed environmental professional with nearly 30 years of experience managing environmental site assessments, investigations, and remediation projects across New England and New York. In his current role, he provides technical and regulatory oversight on complex sites within state and federal programs, bringing deep expertise in due diligence, compliance, and risk management for a wide range of clients. Thank you both for kicking us off today.
Excellent. Good morning, everybody. So why are we here? I mean, everybody's bought something. Everybody's gotten a lemon at some point. You know, the purpose of this and educating everybody and being a resource to everybody is to prevent those lemons. So as Ricky said, to understand what we're possibly getting into before we're getting into things. So why due diligence and who's it used for? Well, it could be for liability relief, to avoid unexpected surprises. Usually the word surprises in a transition means costs or some type of regulatory oversight that might not have been expected. There could be requirements depending on your sources of funding, whether they're from banks, lending institutions, or even private lenders, that could put some level of due diligence requirements on them. And certain types of spills, releases, and contamination are also regulated. Something may have to be done by law. Who needs due diligence? Typically purchasers. It's done on their behalf, but also lenders and banks might require it also. So today we're going to start with a case study regarding a project that I worked on with Cameron for the East Haddam Land Trust. We'll talk about due diligence, the different types of due diligence, the process, the costs, the timeframes. And we'll also talk a little bit about the release-based regulations, particularly that'll pertain to Connecticut, that will start in March 1st next year, which definitely puts a different twist onto how properties could be regulated in the future that land trusts and municipalities might be involved with. We will try to hold questions to the end so we can get through things, but we're going to try to leave time at the end to cover questions. With that, I'm going to stop sharing and I'm going to turn it over to Cameron. And if everybody sits back for probably about 20 minutes, he's going to walk us through a pretty neat case study and that the East Haddam Land Trust went through on a recent property. Let me see. I think it's all yours, Cameron.
Well, hello, everyone. And as Ricky and Tim mentioned, I am the Land Acquisition and Stewardship Chair for the East Haddam Land Trust. And I'm going to share with you some lessons we learned during a very challenging, but ultimately very rewarding land acquisition. Most of the challenges we face related to a significant environmental issue, which is why this presentation is included in this environmental webinar session. But the story covers some other topics as well. So I hope it can also provide some insight into how land acquisitions can develop generally and how they can take unexpected turns over the multiple years that they often take to complete. And my screen is not advancing. Why is that?
Should be on your end, it's nothing that we could control.
I'm just going to stop the share, go out and reload the document. There we go. Can you see it? Oops.
No, not seeing the screen.
Now can you see it?
Yeah, we see your sort of PowerPoint screen. Yeah, now we're full screen.
Okay, there we go.
Slide. Perfect.
So a little foreshadowing of what's to come. I'm going to start with a quote from attorney Keith Ainsworth, and I think many of you probably already know him as an experienced Connecticut land conservation lawyer. And he was responding to a question on the listserv, which is a state land trust forum online, whether a land trust should accept the donation of a property with a farm dump on it. And Keith posted this. He said, "In my opinion, it would be nothing short of reckless to accept a property that contained a known dumping area without knowledge of what it contained." That's a wise statement. And if it holds true for a donation, surely it has to hold true even more so for a property that a land trust seeks to buy. And I think we all know this, but we still sometimes get in over our heads. So let me start at the beginning here and say that this is a map of Connecticut, and there is East Haddam, our very rural town in the southeast portion of the state. And our story starts about 20 years ago or so when the town of East Haddam identified this 127-acre Honey Hill farm site as a highly desirable site for conservation. And the town sought unsuccessfully to convince the buyers to sell it for its appraised value. But the owners weren't interested. And as you can see, Honey Hill Farm is down there to the left, and all of the other colored areas are other conservation properties in the area. So this is really centrally placed and has connectivity, and it lies in a very rural area of our already rural town of East Haddam. So we were very interested in it. It's bisected by power lines, but otherwise it's magnificent. It has, in addition to 15 acres or so of woods, it has 14 acres or so of fields, a stream that flows through a steep decline from a beaver pond, and a forest that's dotted with ancient wolf trees. But because of the power lines that you can see in the middle here and the property's limited road frontage, the appraised value of the land was pretty low, and that was good from a buyer's perspective, but not so good from the seller's perspective. And as I mentioned, it was a stumbling block for negotiations with the owners. So there followed some 2 decades of on and off contact with the owners from both the town and our land trust, trying to find a way to purchase and protect this parcel. But the sellers weren't motivated, and there were multiple family branches and many family members who were part of the decision-making process. And so for 20 years, we made little or no progress. And I won't bore you with all the ways we tried to pitch a sale, but at one point, we already had an OSWA, I'll get back to OSWA in a minute, application pending for another property. I don't know if it's still the case, but at the time, you couldn't have 2 pending at the same time. So we tried forming an LLC to purchase the property and hold it until we could get state grant funding for the land trust to buy it from the LLC. And we spent months on this, but it fell through in the end. There were problems surrounding how LLC members could manage carrying costs, not to mention the COVID pandemic. And ultimately, this idea sank. So to our dismay, the owners opted to put the property on the market for $1.4 million, which was well over its appraised value in late 2022. But it soon became apparent to them there wasn't much interest among either residential buyers or developers for a property bisected by power lines with limited road frontage and on which there was a farmhouse that was in a state of serious disrepair. So one day in the summer of 2022, the sellers came to us agreeing to sell the property to the East Haddam Land Trust at the property's appraised value of some $684,000. Finally, we had a deal in principle and we just had to work out the details. Now, the owners had agreed to sell to us even with our condition that we'd be obliged to buy only if we could successfully obtain a DEEP Open Space Watershed Land Acquisition or OSWA program grant. And I suspect many, if not all of you, are familiar with that grant program. But this was a big concession on the seller's part because getting an OSWA grant can take months and maybe years. So we had to make some concessions of our own. For example, we gave the sellers naming rights for the property, which we normally don't like to do. And then there was the issue of the small farm dump on the property. I will say personally, I've encountered very few properties in rural Connecticut, even older residential ones, that don't have some small pile of metal and glass on them, or any rural farm property that doesn't have some rusty old equipment on it somewhere. It's just the way things were done back in the day. What you couldn't burn, you just dropped in a pile in the woods. That said, the farm dump we encountered here was a little larger than most, maybe 40 feet by 60 feet. And in and around it, we could see air conditioners, other appliances, the usual farm equipment, and some household trash. So what to do? Well, the seller side considered the dump to be a minor issue that would just cost a couple $1,000s to get someone to come in and cart the things away. And considering the length and the tenor of the negotiations over the past 20 years, we knew we would sink the deal if we insisted that the sellers clean it up themselves or pay for EPA compliant review. And the site didn't look so bad that we couldn't clean it up ourselves. So what could go wrong? But I'm getting ahead of myself. In any event, we asked the sellers if we could clean up the dump site ourselves as soon as the contract was signed, but before we applied to DEEP for OSWA land acquisition grant funding, and they said yes. So as Dirty Harry would say, we were feeling lucky, and we took the plunge without having conducted any true professional due diligence. Would I recommend this approach? No, because I'll tell you what our decision led us into. But it could have been much worse. We did get through it, and we learned a lot along the way. We signed the contract with the sellers on August 1st, 2022 to purchase the property for $684,000. But in addition to the naming rights and the farm dump, we had to make one more concession. Specifically, the sellers were intent on getting things done within a reasonable amount of time. And so a term was included in the contract that required closing within 2 years. That's by August 1st, 2024, or the sellers could walk away and look for other buyers. And that seemed reasonable enough. OSWA applications can usually be processed and closed out in well under 2 years. So we felt very confident at the time with respect to timing. And with the contract signed, we got right to work on the farm dump. We brought in 2 dumpsters and we spent a week removing 3 tons of metal and a further 3 tons of rubbish from the dump site. Then a neighbor with an excavator graded the site, after which, to our eyes, the place looked fantastic. And we figured we were done with the farm dump issue. We filed our application for OSWA funds right after that, and we openly stated in the application that there had been a small farm dump on site, but we dealt with it, so there were no longer any environmental concerns with respect to the property. And on May 10th, 2023, DEEP's OSWA division said that our application for acquisition funds had been granted, and they'd provide us $321,000 toward the purchase price. That was great news, but the approval was conditioned on DEEP's separate Waste Engineering and Enforcement Division, or WEED, taking a look at the farm dump and confirming that the site had been cleaned up to its standards. The weed people visited a few weeks later, and maybe we shouldn't have been surprised, but we were. They said further mitigation at the site would be required and that soil testing would be required first of all. So began our environmental odyssey. First thing we needed to do was to hire a consultant quickly, specifically a licensed environmental professional with a reputable firm with an understanding of the state regulation of environmental issues. And clearly we wanted someone competent, but I think experience with state agencies and patience and personal skills are equally important. And we chose well when we hired Tim Myjak and his company, EKI Consulting. You've heard a little from Tim already, and you'll hear more from him when I finish up. But I'll introduce him by saying he's a licensed environmental professional. So if you hear me referring to our LEP, he's the guy I'm talking about. So after hiring Tim, our first step was to take soil tests, and we did that in August 2023. And based on those tests, Tim proposed a remediation plan, which involved removing additional material, and we sent that proposal to Deep's weed division. And with Weed's blessing, we were ready to start work and wind things up, contingent only on later testing confirming that the site was to their standards. But this was going to be expensive, and we swallowed hard when we calculated it might cost anywhere between $30,000 and $100,000. And our land trust is accredited, and I think we run a pretty tight ship, but we're not a deep-pocketed entity. Serendipitously, just a week or two later in September 2023, the State Deep's Brownfields Division announced a new environmental grant program, and that was specifically geared toward nonprofits and municipalities seeking to create park space or greenways using federal CERCLA funds. And needless to say, we applied immediately, and we were, of course, very grateful to hear that our application had been granted on February 22nd, 2024. So at this point, we were dealing with three divisions of DEEP. The OSWA division held our acquisition grant funds, but the weed division needed to sign off on our remediation efforts before the OSWA funds could be released. And meanwhile, the Brownfields division would be setting the conditions under which we could be reimbursed with federal funds for some or all of the remediation work that the weed division had directed us to do. But at this point, it was already early 2024, and you'll remember we had to close by August 1st, 2024, or the sellers could walk away. So this was going to be a complicated dance, and we needed to get it done very quickly if the project wasn't going to fall through completely. The first thing that Brownfields required as a precondition to moving forward and to receipt of federal funds was an EPA Phase 1 report. And our LEP, Tim Myjak, did that for us, but it wasn't reimbursable because while our Brownfields grant application had been approved, we still hadn't signed a contract with the Brownfields division, and that was a prerequisite to reimbursement for any work done. So this Phase 1 was ultimately one of the costs that we had to bear ourselves. In the end, the report didn't shed much light on the farm dump, but it was interesting. And interviews with neighbors conducted as part of the process provided a lot of historical detail about the property that we hadn't known, as well as some amusing anecdotes, including the fact that the resident dairy farmer had been delivering milk by horse-drawn carriage down to the nearby state highway by horse-drawn carriage, even in the late 1940s. I'm going to digress just for a moment to talk about this Brownfields grant program, which some of you may be interested in exploring. It's a great program, and as mentioned, it's geared toward providing funds to nonprofits and municipalities for assessment and or remediation to create greenways and park space. And it works, and it worked well for us, but it is a government program, and with that comes some time considerations and requirements. And one of the most challenging for us was that we couldn't be reimbursed for any work until we got our contract signed, and contract signature doesn't happen overnight. And we really needed to get everything done by August 1st, 2024. But if we hadn't been under the gun due to our own deadlines under our contract with the sellers, the turnaround time, I think, was pretty good. It was about 8 months from the filing of the application to the signing of the contract with Brownfields, and another 4 months to complete our work and get sign off from the other DEP divisions involved. There are some other requirements under the program, including signage like the signage you see here, competitive bidding, and regular reporting. But any of you who've sought state or federal funding before are probably prepared for these sorts of things. So all in all, I think the program, especially as a brand new one, worked quickly, and no doubt the assistance of the brownfields and other deep personnel involved helped us along because they were aware of our time constraints. And if you want to learn any more about this program or any of the other available DEEP grant programs, you can go to the DEEP grant funding portal on the web, which is a great resource. Anyway, back to the story, which I will try to wind up fairly quickly. We're now in March 2024. Our brownfields grant application has been approved, but we can't start work because we don't have a contract yet with brownfields, and no work will be reimbursed if it was performed prior to there being a contract. So at about this point, we went back to the sellers, hat in hand, and asked for a 6-month extension. And I don't know what would have happened if they said no, but fortunately they could see that the end of this process was in sight and that we were doing everything that we could. And they agreed to the 6 months, giving us a brief but much needed reprieve. And we finally signed our contract with Brownfields on May 10th, 2024, and that was like the starting gun for a 100-yard dash. We already knew what we needed to do, so we immediately put the excavation work out for bid, and Brownfields was very helpful in this period to expedite the process since they were well aware of our deadlines. And with the assistance of Tim and his company, we excavated and transported off-site some 60 tons of material, took some additional soil tests, and figured once again that we were done. This was the end of June 2024, and we still had lots of time before the contract with the sellers would expire. So what could go wrong? For those of you who guessed, you're right. The soil tests we had just taken were not entirely satisfactory. And now we're in July 2024 and the clock is ticking. So we went back to the drawing board and we removed another 60 tons of material and transported it off-site. This meant we'd now removed some 120 tons under the direction of DEEP, and that was in addition to the 6 tons we had taken out ourselves in 2022. We had essentially excavated down to bedrock. Further test results were sent to the weed division, and at this point, Tim's intervention and skill and experience were critical. He facilitated a meeting with weed in which we discussed the recent test results, our efforts to mitigate to date, and our plans for the restoration of the site. And the result was a letter from weed in September 2024 confirming we had done what we needed to do, and we couldn't have been happier, and our sighs of relief could probably have been heard on the other side of the state. So we filled in the big hole we had dug, and we regraded the site, and the physical site work was finally at an end. Meanwhile, the letter from the Deep Weed Division, which confirmed we'd done what was required, was forwarded to Deep's OSWA Division, which released our $321,000 in land acquisition funds, with which other monies we raised gave us the $684,000 we needed for the purchase. And at about the same time, some $61,000 of our total remediation costs of what ended up being about $75,000 were covered by the Brownfields Division with federal CERCLA funds. And we closed with the sellers on October 11th, 2024. This was after the August 1st, 2024 date, to be sure, but it was well within the 6-month extension that the sellers had graciously granted us. And since then, we've cut over 2 miles of new trails, installed our signage and directional posts, put a bridge over that beaver brook I mentioned, and opened a beautiful new 123-acre preserve to the public. Wildlife is thriving there. We have bobcats, and we have coyotes, and raccoons, deer, of course. And if we could just get these pesky beavers to keep their dam well repaired, you can see their dam here to the right, and it's constantly leaking on our trail. If they just do what they're supposed to, we'd be in pretty good shape. Would we ever want to go through something like this again? I don't think so, but we learned a lot. First, we learned firsthand the wisdom of Keith Ainsworth's admonition about the importance of due diligence before getting involved in a transaction on a property where there may be environmental concerns. Second, we learned the value of hiring an experienced LEP like Tim and his company, because they've been around the block and they've dealt with the relevant agencies and departments before, and that was critical. And I'd add here that having a good LEP is probably important in any case, whether you're dealing with a pre-contractual situation or whether you're in a post-contractual jam, as we were. Third, we learned firsthand about the great source of funding through the Brownfields Division for assessment and remediation of environmental issues. And that's also likely available pre or post acquisition. And we learned some of the ins and outs of dealing with the applicable rules and regulations and the kinds of timeframes you have to anticipate under this or any other governmental program. Finally, we came to appreciate that a happy ending was never guaranteed here, and that we were very lucky to have emerged from all of this as unscathed as we did. We entered into a contract where an environmental risk was known, but our initial assessment of that risk was flawed. So you could say that the problems we encountered after that were problems of our own making, but ultimately our issues were solved successfully. And there was, in fact, a very happy ending due to the technical and strategic assistance we received from our LEP and with the help of many people at multiple departments of DEEP, whose assistance we are very, very grateful for. So that's it for me, but I'll stick around until the Q&A session after Tim's presentation. And I'll stop sharing my screen.
Hopefully everybody can see that. Can everybody see my screen now? Or
Yep.
Can you see?
Yes.
Excellent.
Yep.
So, let me get the thing here. So why due diligence? I mean, that was a absolutely terrific case study, you know, probably more along the lines of what some of you folks might encounter during some of your own projects. But, you know, where did due diligence start and why do we do it? Well, I think a lot of you probably have heard about Love Canal. You know, in the 1970s, people were getting sick. You know, there were investigations conducted, and, you know, lo and behold, the government and some chemical companies were just burying chemicals in that area up in Niagara, New York. It happens here in Connecticut. It's not just in other areas of the country. The Newhall neighborhood in Hamden, Connecticut, back in 2007, industrial waste used as fill, buried across neighborhoods and within schools. If you go to the Stratford town website, I did this just this week, and you could see there's active activity associated with the Raymark Industries waste being buried all across certain areas of Stratford. I thought it was pretty interesting that, you know, if you have nothing else to do with your kids on a Friday or Saturday night, you could probably log into the live feed of the ball field that was filled with asbestos and chemical waste that's being remediated. So log in if you're looking for something to do on a Friday night. So particularly after the initial findings and concerns around Love Canal, the federal government started getting involved with the passing of the CERCLA activities in the early 80s, which were amended in the mid 80s, which turned into what we know as due diligence to try to protect prospective buyers before they take title on properties. And that's an important thing to acknowledge. Doing the proper level of due diligence before you take title on properties, specifically for CERCLA liability relief. Meaning if something's identified, even if you did a level of due diligence, the federal government might back you up with some funding to clean it up. Otherwise, you could essentially be held responsible for doing any type of investigation and cleanup to comply with both EPA or state regulatory standards. Out of this, ASTM, not a regulatory agency, but there's a lot of protocols and standards developed by ASTM, developed a phase 1 standard. It's been updated many times throughout the years. And then the federal government adapted all appropriate inquiries level of due diligence, which relies upon the ASTM, particularly the phase 1 environmental site assessment standard, as the standard of care for due diligence when people are buying and selling properties. It's also typically the standard of care that both lending institutions and state and federal governments and agencies that are providing grants would require typically before they give money on properties. Since the Newhall neighborhood in Hamden, it was such a wake-up call for the state of Connecticut. Even towns that are doing additions often to schools or municipalities, and if they're going after any type of state funding, the state requires, even if the town owned the properties for 50 years, to do some type of level of due diligence, typically a phase one, to understand what the history of the property was before they even give the municipalities funding to do projects, because they don't want to put good money to what might be a bad site with some type of liability. In addition to the federal due diligence standards, the state of Connecticut, back in the late 80s, particularly around what was called the Transfer Act, developed a site characterization guidance document. It's a protocol the state of Connecticut took, like everything else we do in Connecticut, kind of one more step beyond the federal guidelines and developed protocols to what they saw was fit for doing phase one environmental site assessments, phase 2s and 3s, and remedial activities. This document also has been updated several times throughout the years, and there's more to come with the adoption of the new release-based regulations, which will occur on March 1st of 2026. So we do due diligence when we buy commercial properties for many other things, termite inspections, roof inspections, you know, whether a renovation or a different use has the capacity and the permitting requirements for a property. So why not do environmental due diligence so you know what you're getting into before you take title on a property? Why do we do phase ones? Sometimes it identifies a concern right out of the box, but more importantly, most of the times when we do some type of level of due diligence, like a phase one, it identifies the potential for a problem, the potential for a release. And that's as important because the phase one is a non-intrusive assessment. It doesn't go out and do test bits. It doesn't do digging. It doesn't take samples. It's a development of the history of the property to identify whether there's potential for environmental impacts. So what are the types of environmental projects that myself and my firm and other environmental firms get involved with? Sometimes we recommend them. Sometimes it's asked of us by the clients and or even attorneys. Well, we do phase one environmental site assessments. If potential or known environmental impacts are identified in a report, we might do phase two investigations to identify the presence or absence of a release. We do phase three investigations. A phase two, is it there or not? A phase three, how widespread is it vertically, horizontally? Did it migrate somewhere? Did it impact groundwater? We develop remedial action plans, ways to demonstrate compliance for potential uses or future uses on the property, how to clean up a property. With that, once the remedial action plan is developed, we could develop costs, cost of closure, cost to demonstrate compliance on a property. When we assisted East Haddam Land Trust, we had to go after the grant, and we had to develop an understanding and a cost and put a number to that. If it wasn't an open checkbook. We oversee remediation. We work on building hazards assessments. You know, you might acquire a property that has a building on it. Maybe the building needs to be torn down. Maybe the building needs to be renovated for another use. Asbestos, lead, PCBs. There's ecological risk, vapor intrusion, environmental compliance. We work with public outreach. I mean, it's very possible to take over a property that has had industrial, commercial use, environmental impacts, a landfill, using state funding, turning it into an open space. A lot of people could be afraid of that. So sometimes we have to educate people to what's going on. We provide technical support. We work with legal counsel. We put properties into liability relief programs in Connecticut, particularly properties that could be brownfields. Liability relief. If you buy a property in the state of Connecticut, liability relief might require you to clean up the property to the property boundaries, but not have to clean up contamination if it left the property. Why is that important? I mean, you might be held responsible to clean up the property because you're taking over title on it, but at least you're not going to be responsible if someone got sick years ago from the contamination on the property, or if it's leaving the property. And that's a program that typically has to be applied for before you take title. It could take up to 3 months to get approval from the DECD and the DEP. There are other forms of environmental due diligence done at the initial onset of looking at properties. There is a ASTM standard also for transaction screens, and there's also desktop reviews. These are environmental due diligence light. They do not qualify for circle liability protection. They do not follow the AIA. I'm sorry, not the AIA, the all appropriate inquiry standards. But for certain lending institutions, it could be the minimum level of due diligence required. But I always recommend a phase one. I mean, the price difference between a transaction screen and a phase one could be $1,500, $2,000, but the level of due diligence and essentially the dig into what the environmental history was and whether there's potential impacts or not, pretty important. A transaction screen would cover a site walk, limited file review, and provide an opinion, where a phase one, we'll get into it in a couple minutes, covers a lot more history review to understand if there's a potential presence of environmental impacts. One thing that's very important, if in looking at properties to take title, if someone hands you environmental reports, that's wonderful. We always want to look at them. But in order to qualify for circle liability, you have to have ownership of said reports. So ownership would be either the consultant working directly for you, or if a phase one, for example, was done in the last 6 months before you take title of the property, getting a letter of reliance from that consultant that you could take that report, you could take that work and rely upon it as if you were the person who essentially paid for it. So it's really important. Don't rely upon a report that's just handed to you. So phase one environmental site assessments, they're protocols. We talked about the standards a little bit. We talked about why, they're typically done on behalf of a purchaser, although some sellers will have them done ahead of time. A lot of people come to us and say we want to get our property ready for resale. So we'll write our proposal in a way that we'll write it for the seller, but we'll provide a letter of reliance, to a buyer if they're going to use the report for their own purposes. We look for potential indicators of environmental impacts. It is non-intrusive typically, based on the standard of care and the standards. It's essentially a paper trail report by looking through different types of records and coming up with conclusions. And it's important to know it has a 6 month shelf life. If you're outside of 6 months of your closing, you could do an update, but you have to have that report dated typically within 6 months to qualify for the circle liability. And depending on the programs and if you're applying for grants, there's a possibility that you might have to meet both the ASTM standard for phase one care in addition to the site characterization guidance document, which is DEP Connecticut specific. But it's very easy to write one report that covers both standards. Budgeting, I mean, typically a phase one could be in the $3,000 to $9,000 range. It really depends on the complexities. And depending on the availability of records, access to a property and review, typically a phase one would take 4 to 6 weeks. Can it be done in 3 weeks? It can if everything comes together. But typically we like to see 4 to 6 weeks. Certain public records we have to FOIA. So we have to give those agencies, a minimum of 2 to 3 weeks typically to even see the records. So what does due diligence, specifically the ASTM and the site characterization guidance document, require for phase ones? Historic records. We look at aerial photographs for, I'm going to speak specific to Connecticut, but elsewhere in the country also. We look at aerial photographs in Connecticut back to the 1930s. There's complete flight lines in the 1930s, back in the 50s, and then somewhere around 1965 to present, there's aerial coverage for the state for every 5 years. It's amazing what you could see from aerial coverage by looking. You see piles, you could see old buildings, trees removed, roads that went back into the middle of the woods or on a property that are no longer there. Why was the road there? We look at Sanborn fire insurance maps, and they're not available for every town or every area of a town, but industrial commercial areas, Sanborn maps could tell you a history of what type of activities were on properties, where tanks were, what kind of chemicals could have been used. We look at city directories. These are like reverse telephone books that you could look up an address and understand just by a title or, a name of a business, what might have been there. We try to talk to as many owners and tenants that we could possibly get in touch with. Now, we have to do our work within the limits of our scope, within our budget, and within a time frame. So there is a point where we have to sometimes just put this down and say, this is the information that we have, and report it. And if there's a data gap, like we couldn't talk to a tenant from 1930, we have to make a determination on whether that data gap is important or not to the conclusions of the report. We order a database search typically. There's a company called EDR, and we spend about, could be $700-800 on these reports. That's part of that $3,000 to $3,000 phase one cost, where we get federal and state records. We don't have to necessarily go to records halls like EPA Boston Region 1. They're usually typically included in these reports. But we do also reach out to regulatory agencies. We go through municipal records. We do reach out and look at DEP public file room records. Very important. We do a thorough site investigation. We walk the property, document the current conditions. We look for potential concerns associated with chemical and petroleum product storage and releases. And then what's most important, we render an opinion as to what the history of the property was. We document it with photos, we document it with sketches of what we saw, and then we provide a conclusion on what type of environmental concerns could be on a property. Why do we do this? To provide recommendations if there's additional investigation needed, to help plan for remediation if that might be needed. We try to prevent delays and disruptions. Cameron, they were right on track. They identified the farm dump. We didn't. We weren't on board at that time, but they had gotten the ball going. If they went for their funding and then the state said, go do a phase one, it could have gone a whole different way, and there could have been a lot more delays. So, by doing environmental due diligence early, or at least getting your toe in the water with talking to the right people, you might limit your delays on a property closing. We look for restrictions that might be on the property. Part of cleanups these days and a form of remediation might not necessarily be just digging it up. It could be capping it in place. It could be some kind of treatment system. It could be restricting residential or some type of passive recreation use, acknowledging that there's contamination there and putting a use restriction on the property. So do you know that there's a use restriction on the property before you buy it? That'd be pretty important to possibly know. We look into whether there's ongoing obligations, if there's ongoing lawsuits and things like that filed for the property associated with environmental concerns. And sometimes it's just stigma. It's that old building that's around the corner, and everybody thinks there's something wrong with it. Well, that's our job. Is there something wrong with it? Is there potential liability or not? And sometimes, in the commercial world, it's to protect resale value. A buyer might be a cash buyer, but then they want to finance against the property down the road, or they want to sell it. If they do their due diligence up front, at least they'll know what they have for future planning. So some of the objectives of due diligence, like a phase one, was there a release identified? Is there a likely release that could have occurred? Is there some kind of activity going on the property that could cause a potential future release? These are recognized environmental conditions. This is the purpose of doing a phase one, is to identify the potential for recognized environmental conditions. Threat of release, a known release, or potential future release. So some examples. We look at previous environmental reports. A lot of properties have been bought and sold over the years. And we look at we look at a previous report that could have been done by another consultant, or maybe there was a spill reported on the site. and we identify whether it was cleaned up correctly. And believe it or not, cleaned up correctly to a standard that could have been even 10 years ago or 15 years ago might not be what's needed for current standards. Are there historic concerns on the property based on use? For example, operations like dry cleaning. Is there a material threat of release? We walk around and, there's drums. We don't know if the drums were concerned, they released or not. Remember, a phase one is non-intrusive. So those are some of the objectives when we look through historic records and we do a site walk. Some of the other phase one objectives, as I mentioned, what was done in the past, is it still meet current standards? There could be documented releases or concerns where there was investigations and or cleanups. Do they meet the current requirements? Do properties have restrictions on are there active vapor mitigation systems? You buy a property that has a house or a structure on it. There could be costs associated with some type of form of protection for the tenants. We work with properties where there was environmental impacts that left the property, and there's a whole neighborhood that are on water treatment systems, for example. There's cost. Who takes on that liability in the future? And then there's also business risks, things that might not be considered recognized environmental conditions, but could have some type of implication, financial implication to a property. For example, a lot of properties could have been agricultural orchard. State of Connecticut has standards for spills and releases associated with pesticides and herbicides. But if they were done in a manner that followed the law when they were applied, having said chemicals in the ground might not require remediation, in a former orchard. But now if you put people on it for recreational activities, or even if something's going to be split off, you might have a big property, but to raise funds, you subdivide a parcel. That soil, even though it was a farm, has environmental impacts. If something is dug up or moved, it might have to go somewhere, and that soil could be regulated. So that could be a business environmental risk, even though it's not a active or known spill or release. How does that material be handled? How would that material be handled? Again, the site characterization guidance document goes beyond just recognized environmental conditions as identified in the ASTM phase one standard. DEP also addresses everything as areas of concern. An area of concern is much broader than recognized environmental conditions. So it's important to know who your audience is. Who are you having your due diligence done for? Some banks don't want to know anything about following the site characterization guidance document. They only want to follow the federal standard. But if you're going after state grants, state funding, you probably are going to have to follow the state standard also, which under the definition of an area of concern, it's anywhere where a chemical or petroleum product could have been used, stored, or disposed of. So, you have a farm, let's just use a barn. I'm trying to stay away from the industrial setting, but you have a barn, and in the back corner of the barn, there was a cabinet where 5-gallon containers were stored for diesel and gasoline. That's an area of concern. Just because they stored those containers in a location on the property, that wouldn't be considered a recognized environmental condition. But if you had to satisfy the DEP site characterization guidance document, just visual observations of that storage area wouldn't be enough. You might have to do some type of soil testing around that area to satisfy this requirement that there's been no spills or releases. So know your need, know your level of due diligence, and who you have to satisfy when you do your due diligence. Takeaways: a lot of conclusions and reports are professional judgment. Don't always go with a consultant that's going to provide you a $1,500 phase one because they're providing a $1,500 phase one, not a $3,000 phase one. I highly recommend talking. Most of these deals have attorneys involved, legal advice. Work off of referrals. Don't go to the phone book. There's a lot of environmental firms out there. There's a lot of very capable environmental firms out there, but a lot of them also cut corners so they can make their money and, get out a product. And sometimes that little extra money is well spent. Why do we do it? Is to reduce uncertainty. There's no 100% given with anything. We could look at all the aerials, for example, the East Haddam Land Trust property, look at the size of that. I mean, if there wasn't material physically located at the surface, how would anybody even know that, there was so much material buried? But we try to use multiple lines of evidence to draw conclusions. Does the paper trail add up? Multiple lines, what do we know? Who are the tenants? What do the aerials say? What do the records say with even building department records of what was on the property? And then we try to draw our conclusions. Non-ASTM phase 1 type items that are also often looked at, asbestos and lead containing materials, PCB materials, and building materials. Whether there could be radon, it's all over Connecticut. I'm sure many of us have radon mitigation systems in our homes. Drinking water concerns, whether you have wetlands, floodplain, depending on how you plan on reusing the property in the future. Cultural and historic resources can be looked at as part of due diligence. Often with industrial properties, particularly if a business is being sold, there's OSHA compliance and permitting type issues that are part of due diligence, and health and safety issues. Ecological resources and endangered species. I'm sure everybody knows about this, but there could be restrictions on what you might want to do on the property based on these things. These types of due diligence aren't part of a standard phase 1. Some consultants may be able to add on these types of levels of due diligence, but not all of them. Sometimes you have to go to specialty consulting firms to evaluate these type of things. But just again, these are not typical things part of a phase 1. So how might an open space, watch my time, and land trust transactions be regulated, again, to satisfy grants, satisfy loans? There could be existing orders or violations on a property. I've worked with municipalities that have owned properties for years, and they found underground storage tanks because there was an old foundation or old home out in the middle of the woods. Structures are often removed or buried. That could be, years ago, you just push it into the foundation. That could be a liability. Again, if you're something like an orchard, if you're looking to do anything on the property and you generate excess soil, that soil could have even low-level impacts. But I always use the analogy, you can't send it to a ball field, you can't send it to a playground because, for example, that orchard soil has lead and arsenic typically in it. During a phase 1, we also look at what could be migrating. We draw conclusions based on records, what could be impacting the site from off-site, what could be migrating onto your site. And then in addition to typical state cleanup standards, there's a set of standards called significant environmental hazards, and those are reporting requirements more on the, I'm going to use the analogy, lights and sirens. A lot of cleanups we do have timeframes set to them, and I'll talk about that in a couple minutes, but certain types of environmental impacts, when we identify them, have to either be reported by the property owner, or some of them are so severe, if the property owner doesn't report them in 24 hours or less, I'm legally obligated as an environmental professional to report them. That's typically something more like free product, environmental impacts in drinking water, a vapor issue that could cause an explosion. That would be like an imminent, significant threat. But there's other threats that require that level of reporting. If you just have 30 times an action level, that you'd have to report them to the state of Connecticut. Evaluating this, looking at historic reports and data, sometimes you flush out, things that are considered significant environmental hazards. What's done after the phase 1? Well, if you identify recognized environmental conditions and areas concerned depending on which standard you're following, due diligence or both, the next step is typically to develop a conceptual site model. If there was a spill or release, where's the most likely location? What are the chemicals that could have released there? And develop an investigation program. We don't want to go out there and just rid the site and spend tens of thousands of dollars. We try to go to the most probable location to identify whether a presence or absence of a release. That's a phase 2. Simply presence or absence of a release. Drill holes, put monitoring wells. Sometimes it's as simple as using a shovel. Take a sample, field screen it with sometimes some instrumentation, but more often than not, get samples to a lab and test for the appropriate contaminants of concern. Now, if there's a release identified, well, if there's no releases identified, that could often be the end of your level of due diligence. If there are releases, even if there are detections below state cleanup standards, you might not be done. Because we don't know, we can't price out what are the environmental liabilities, and we can't develop a remedial action plan by just putting a hole in the ground, for example, by an underground storage tank and saying, yeah, we found, fuel oil or gasoline contamination. We don't know how far it's spread by just putting a hole at the most reasonable location to identify presence or release. You might have to go back and do phase 3 level work, delineate vertically and horizontally the extent of contamination so we can understand what the liabilities are to clean up a site and demonstrate compliance. A phase 2 could be as low as a $15,000 item to, a phase 3 could be up and over $90,000. It really depends on the complexities. I always chuckle when potential clients say, hey, I'm buying X, what's it going to cost? And I'm like, I don't have that crystal ball. We physically have to be there. We have to touch it. We have to get the samples to the lab to understand what we're dealing with. Once we understand what we're dealing with, we typically will develop remedial action plans or costs of what it could take to clean up sites and close them out. Sometimes we make estimates, develop estimates on our own. Other times we bring in specialty contractors and we get estimates from them. At any given time, a consultant could start drawing conclusions on what it might take, what it might cost, but the more information they have, the higher level of the phase 3 investigation work that's done, you're going to narrow down what that level of cost and liability might be to a project or site. So let's just step away a little bit from due diligence for a couple minutes and talk about what's coming next here in the state of Connecticut. Since the late 80s, we've been regulated by the remediation standard regulations that specifically were developed for Transfer Act sites. Transfer Act sites were sites that were dry cleaners, auto body shops, furniture strippers after 1967, or generated 100 kilograms of hazardous waste after a specific month in 1980, I believe. So a lot of other sites, even including gas stations, aren't Transfer Act sites. So Transfer Act sites, when they were bought or sold, you had to provide notice to the state of Connecticut. Certain spills or releases, when they occurred, you had to provide notices to the state of Connecticut. Those were the sites that got put into programs since the 80s and were required to do investigations and cleanups. A lot of other properties, when contamination was identified, did not require notification to the state of Connecticut, did not require compliance with the cleanup standards. Well, the regulated community thought that was off kilter. They're very upset with the Transfer Act, that it held up deals. And it took 12 plus years of lobbying and working with DEEP to establish what was just passed during this last legislative session as the release-based cleanup regulations. So what does that mean? Well, when you identify a release, you're required to report it to the state of Connecticut. Now, a gallon of, when these regulations first were being developed, literally if someone dropped a gallon of laundry detergent in a Walmart, that would have required a notification. Since then, they've defined a little bit more what releases are. But releases moving forward, identified, visually, it happened right in front of you, a tanker truck rolled over, or your consultant takes a sample, out in the middle of a farm field at a farm dump. If you identify it, you will be required to notify the state of Connecticut. When you're required, it could require additional investigation and a remedial plan be developed, typically on behalf of the property owner. But if you are taking title on a property, you could be the responsible party moving forward. So this is mandatory reporting on sites in the past that did not require reporting. Again, there's some pretty strict definitions of what a release is, what a maintainer release is. I'm sorry, maintainer, if I'm going too fast, how quickly you have to report it and what actions have to be taken. So, there's discovery, there's a new program for significant releases, how quickly you have to investigate them, how quickly you have to report them. There's multiple lines of evidence, even though these regulations were passed and they're going to go into action on March 1st, there's actually a lot of stuff that is still being developed, particularly by DEEP, to support it on what multiple lines of evidence means. That's what does it mean to identify a release? And there's a program, what you have to do first year, second year, depending on the severity of the releases, who's responsible. The goal of the state of Connecticut with these new regulations was to cast a broader net to capture essentially all contaminated sites. But they also, within that net, were trying to have different sieve sizes where the big complex sites, they're still going to take 8, 10, or 20 years to get them cleaned up. But smaller releases, that could be skeletons in the closet, for example, you could get them to closure maybe in as much as 3 months. I think something like Cameron's presentation is an example of something you could identify a release, but you get it to close, get it to the state of Connecticut being happy quicker to keep these property transactions and due diligence moving forward quicker. There is a file cabinet exemption. So if a consultant is doing due diligence for you and they look, it's literally called the file cabinet exemption. If they look at a report that was done prior to March of 2026, and it says there's contamination on a property, that would not require the reporting of a release. That doesn't mean that a purchaser could become a maintainer of a release, and that's just getting maybe a little bit too much into the weeds. So if you have questions about that, reach out to me in the future. And there's a roadmap. I know this might not be super clear based on the size of the font, but it's this, then this. So there's a lot of different requirements based on the severity of releases identified, how quickly they could be cleaned up, who could be cleaned up, and who could essentially sign off on them as being cleaned up and completed in compliance with the state standards. A state agency like the DEEP could maintain oversight of a release, or they could pass it down to a licensed environmental professional such as myself, or in the future, smaller, less severe releases could also be cleaned up and signed off by a program that's going to be called a permanent environmental professional, which we don't even have that completely developed yet, although the new regulations are going to come out and be in play on March 1st. So there's different tiers of assessing risk, and with that risk, there are different requirements. And guess what? There's fees. What's interesting in the past, with a Transfer Act site, you put it in, you spent your $3,000. Now, every release could have a potential filing fee. So you could have a site where there was the loading dock, there was a stormwater drain, there was an underground storage tank, there was the back area where they dump stuff over the hill. Each one of those could have a filing fee and a specific time frame and reporting requirement. With the new standards, as licensed environmental professionals, the most important thing to know, we also have new tools to demonstrate compliance. We have all the old tools, but they stacked on a whole bunch of new tools to the regulations also. It's going to be the wild, wild west for a little while. Of importance to this group, most soil impacts in the past were either regulated if it was residential or if it was industrial commercial, and there was nothing else. So for example, if there was hydrocarbons in the soil, the action level for residential might be 500 and the industrial commercial might be 2,500. Why the difference? Because the industrial commercial people don't go out and play in the soil as much as the residential kid that's going to be in the backyard all the time. Well, there are new passive recreational standards that are part of the new regulations, and the numbers and the cleanup standards kind of fall somewhere in between. But if you're going to use those to demonstrate compliance on your sites, you're going to have to use use restrictions. Use restrictions demonstrating that it's not going to be used for industrial commercial use. Rail trails could be a big example of this. Properties with orchards and farms, because of the pesticide applications, you might use this type of set of regulations to demonstrate compliance. Permits by rule, certain types of contamination, again, like the farms, the ash material from, burning of wood, believe it or not, is a contaminant. There's certain things that could be documented on land records and often left in place also. Let's not forget emerging contaminants, part of due diligence. I think this group is probably a group that likes being outside. If anybody likes being outside, they probably like their Gore-Tex clothing. I'm guessing this group likes to cook. We probably all like our nonstick frying pans. Well, PFAS, that's an emerging contaminant. There's actually been known for about 10 or 15 years. Federal government, particularly with naval bases and airports, because there's a firefighting foam called AFFF that was also a PFAS compound. This is an area that's yet to be figured out. We're starting to see standards for groundwater and drinking water, but as far as where it lands with standards in soil, we still don't really know where this area is going to go with the regulatory agencies. The federal government, I think with the Trump administration, pushed this off to 2027 for further study and assessment to make sure we understand it before we just put numbers to things. A lot of chemicals that we regulate in the ground are cleaned up or treated to the parts per million, or the parts per billion concentration level. PFAS is regulated to the parts per trillion level. You move a decimal point on an action level could mean the difference of spending tens of thousands of dollars or spending millions of dollars on cleanup. And one of the biggest low-hanging fruit we still see is PCBs. PCBs are very highly regulated and become very problematic on projects because they're not only regulated by the state of Connecticut, but PCBs at certain concentrations are also highly regulated by the EPA. And once you get two regulatory agencies regulating what you're trying to do on a site, it gets very costly and very confusing. So what do we do as consultants? The most important thing is try to figure out, how do we keep your deals moving forward? How do we educate buyers and sellers? I always use an analogy. You could have a wonderful used car, but it has a transmission that needs to be repaired, or a dent in the front fender. Well, or something on the Carfax. That's negative equity. That's what environmental consultants do by doing due diligence, is we try to evaluate if there's potential for that negative equity. Something that you could take on that's going to cost you money. And if it's there, does it mean that the East Haddam Land Trust should walk away from 20 years of chasing a parcel? No. It means we have to try to get the buyers and the sellers and funding sources that could be out there all working together. Does environmental due diligence squash deals? There is no doubt. Sometimes sellers are just, that's it, my property's worth this, that's the fair market value, they don't care. But a good consultant, good legal counsel will really work to try to keep deals moving forward by educating buyers and sellers. Luckily, a lot of the projects that you might be working on, if they're, due diligence, the phase 1 level, that you're probably going to have to own that. But if something's identified, there's probably funding sources that could be available through the DECD and the DEP even the EPA. But do your due diligence. Don't assume anything. Just because you walked on the property for 10 years, you never know what could have been there 50, 60 years ago. Get your attorneys, get your environmental consultant there at the beginning. I tell all my clients, potential clients, I will drive, Connecticut's small. I could be anywhere in Connecticut in an hour. I'll walk any site you want. I'll look at any reports you want. I call it over the weekend before I charge you anything, because I don't know what you need. Any consultant that writes you a proposal and says, I'm not going to think about it until you start paying me, it's probably not the type of consultant you want to work for. Work with consultants, work with attorneys that are partners in what you're trying to achieve, so we could be proactive at the beginning and protect, your environmental liability by doing proper due diligence. I don't think I did bad. We have about 20 minutes, it looks like, for questions.
Awesome. Thank you so much, Tim and Cameron. Really quick before we start questions, I just want to let folks know that so we'll make this recording available via our YouTube channel. We'll also share out some resources that are relevant to this topic. There's the Connecticut DEP keeps an active list of contaminated sites. We also have free resources for public environmental records search. And CLCC also has our sample policy library. So we'll also share all those out. If folks want to put their questions in the chat or use the raise hand function, would love to open it up to whoever wants to ask questions.